Right, good evening, everyone. Yeah, so yesterday what we did was to start some kind of a segmented, if you like, generalized revision across the 6 subjects. So we started with the Ghana legal system, work our way up to contract. The idea was to try and find out which topics have been examined before in the past questions, and then probably try and make some reasonable speculation as to potential, if you like, areas, of course, without any guarantee or assurance. But we did note that at this stage, any question you come across, you don't have to ignore it so long as it's related to the subject. You do well to look at it and try how you work an answer to that. So tonight we would like to continue by extending what we did yesterday to the land law. Yeah, so before we come to the other areas, because like yesterday we started the legal system and legal method and then the law of contract, but tonight, let us start with the land law. So this is what we are trying to do. You want to find out which questions or which topics have been examined before as far as land law is concerned. So if you are sufficiently familiar with the past questions, which areas in land law have been examined before? Yes, if you remember anything, just say it so that we just note it. For the past question, has there been any question on land law? Yes, anybody? Has there been any question on land law? I mean, if you look at the, for last year there wasn't any question, but the year before, if you look at the question, okay, let me see, somebody has put something there in the chat. 2016, okay. So 2016, Jacqueline, what question came? What topic? If you are not, so I have to go and pull the records. But if you have it, just, yes. What topic came in 2016? What was the question? Something about head of family. Okay. Well, we haven't seen the question, so we don't know. So is it about like capacity, or is it about alienation? Is it customary land law question? In which case, you are talking about who are the proper person. Okay, the usufructuary interests. Okay, all right. So I'm told that the 2016 there was a question on the usufructuary interests. Okay. Alienation. Something like that. Okay. But the point to note is that this was before Land Act 2020, Act 1036. Good. So we have to also appreciate that ever since this legislation came, we haven't had any question on land law. Let us keep that in mind. And we, in terms of, what probably to pay attention to, my suggestion will be that you go back to the basics. Yesterday I talked about the basics. The basics, like that is to say that don't let us be so fixated with the only advanced topics or topics which sounds a bit complicated, so that we ignore the basics. If we look at your examiners, if you think through the kind of questions that they bring, you get the sense that they appreciate that you finish the LLB either a year or some of you 2 years or 3 years and so on. And for that matter, the emphasis is not to become too sophisticated with you, but just to test your appreciation of very simple and elementary things. And that is why I told you yesterday that in your preparation, don't ignore the so-called simple topics, right? Okay, so somebody has put a certain question here. Yeah, so that's supposed to be like the 2016 question. Okay, let me copy it and paste it here for all of us to see. Thank you, JJ. You say JJ Rollins never dies. Okay. So this is the question the person put in the chat. Let me paste it here. This is like the 2016 question, which came. So, but you see, the good thing is this same question, for example, could be repeated. And then we need to find out, in terms of the law, has there been any significant change, right? As far as the law is concerned. So let's look at the story together. Amerley is the daughter of Ajorkor, subject of Stool in Accra. For 60 years, Ajorkor farmed on vacant Stool Land at Nkwantanang near Madina and put up a hut in which she kept her farm produce. Amerley required land to build a house, and her mother, Ajorkor, gave her a portion of the land she farmed upon at Nkwantanang. When she commenced building operations, she was confronted by officials from Guard Petroleum Company Ltd, who claimed their company obtained a grant of land on which Amerley was building from the Stool. They produced a document executed by the Mantse and his elder for the company. Amerley and her mother have consulted you. What are their chances if they go to court? Support your opinion with decided cases in reference to test writers. Okay, so this type of story, despite the fact that has come in 2016, can perfectly be repeated in the current year. And as we have always recommended, that the IRAC applies to all type of problem question, so that you have like a good logical structure. So what are the area or areas of law which are implicated by the facts? Anybody? Yes. What are the areas of law implicated by the facts? Yes, George.
Alienation of family land, or stool land, sorry.
Alienation of stool land. Okay.
Sir,
Yes.
also I see right over land or right to land, specifically usufructuary interest, or interest in land, specifically usufructuary interest.
Interest. Okay. But the two, are they irreconcilable? Are they reconcilable?
No, really.
Okay. Yeah, so alienation of Stool Land. But you also talk about the usufructuary what interest.
Yeah.
Okay, but the bigger area, is the customary law interest in land, specifically Stool Land and its alienation. Now, as we work through, we come to a stage as whether we are talking about the allodia or usufructuary interest. That is why I just use like the general concept, like the customary interest in land. Then, as we work through itself, you have to start from the allodia, and then the probably the usufructuary interest or the customer's freehold, as the case may be, then that will fall into proper place. Okay, so we've delineated the general area that what is really at stake at the big area is the interest in land and customary law, customary land law interests, specifically Stool Land and its alienation. Okay, so now let's get the issues. So what issues are we identifying? As I said, the good strategy is always go sentence by sentence quickly, so that as you do, if it provokes issue, you can quickly formulate it. So Amerley is the daughter of Ajorkor, a subject of last two in Accra. Does it provoke any issue? Or we should keep reading?
No, it doesn't provoke.
No, I think we can raise issue from there.
We can raise issue from there.
Yeah, so I think that will satisfy the usufruct bit of it, whether or not Amerley being a subject of the being a subject of the last two land gives her right to that portion of the land.
You want to say that Amerley is entitled to usufructuary interest?
Yes, yes, yes.
So whether Amerley, by virtue of being a subject.
Yeah. So can it be whether or not Ajorkor,
okay,
Ajorkor being a subject of last two?
We come to the next.
Oh yeah. I think it's Ajorkor rather, because Amerley is a daughter. Yeah.
Yes.
Yeah. So I think we have to change the name. Yeah. Thank you for the correction. Thank you for the correction.
Being in possession of the land for 60 years.
Of being a subject is entitled to.
Yeah, entitled her for.
Fred, I was thinking that would really be a defense, for, let's say, adverse possession. Granted, the land even belongs to the other party. Oh,
okay. As it is now, we haven't settled, but at least we flag it. Okay, we flag it. So let's move on. We come back. So for 60 years, yes. You want to say something?
Yes.
Yes.
I think, is it Amerley being a daughter of Ajorkor, whatever is not in dispute.
Okay.
But the issue should be raised here is whether, I mean, Ajorkor, I believe is a female. I mean, being a gun, we know patrilineal. I mean, give a daughter, that's Amerley, that entitlement to, as it were, have interest in a family land or stool land, whose descendant is a female from a gun descent.
Oh, okay.
But I think that will not be contemptuous, because looking at being in the nature of usufructuary.
I think it will be contentious because the guns are patrilineal in nature.
Yes, but you see, there's difference between inheritance and alienation. So that is something we should take note of.
So once Amerley is a descendant of Ajorkor, who's a female, subject of a gun's tomb, she cannot have interest in a stool land. Yes.
But I think I agree with you. It's not contentious.
Please, we are in land law.
Let's
move on. Yeah, I think that's all the major issue here.
Yeah, let's hold on. Let's move on. Yes. So for 60 years, Ajorkor farm on vacant Stool Land at Nkwantanang near Madina, and put up a hut in which she kept the farm produce. Any issue?
Yes.
Yes, Doc.
Okay, one person at a time. Okay. What is
so,
the issue?
Doc, I think we can talk about. All right, please go on.
Whether or not Ajorkor be in possession of the land for 60 years, grant him the right, usufructuary right over that land.
Doc, I have a different issue in relation to that.
Yes, go ahead.
So whether or not Ajorkor being in possession on the land for 60 years gives him adverse possession or adverse rights.
Why do you?
Okay, so why I said that has to do with the resurfacing of Guard Petroleum. And so even if we make the analysis and come to conclusion that Guard Petroleum indeed owns the land, then we can use the 60 years on the land as a defense for Ajorkor.
Okay, we come back. Okay.
All right.
Okay. We've noted that that Ajorkor was a 60 years possession. Reinforces claim to usufructuary interests.
Sure.
Yeah. Okay, so Amerley required land to build a house, and her mother Ajorkor gave her a portion of the land she farmed upon at Nkwantanang. So that same land that she's been on for 60 years, she gave a portion to the daughter to build. Is there any issue around that?
Yeah.
What issue?
Whether or not Ajorkor can alienate a portion of that land to Ajorkor.
Oh, okay, as whether she can.
Whether or not Ajorkor can successfully
not Ajorkor
can successfully alienate.
Or maybe should you say unilaterally? Because like she seemed to have done
Yeah,
it by
yeah,
herself.
okay,
isn't it?
okay,
Whether or
okay.
not Ajorkor can unilaterally alienate
Yes, yes, yes.
portion of
The
land
land.
to Amerley. When she commenced building operations, she was confronted by, let's color this so that.
Okay, I get it.
When she commenced building operations, she was confronted by officials from Guard Petroleum Company Ltd, who claimed their company obtained a grant of land on which Amerley was building from the last two. Good. So, any issue here?
Yes, sir.
What issue?
Whether or not LASU can unilaterally alienate that land to the petroleum company without the consent and concurrent of Ajorkor.
But don't
Okay,
forget.
so Doc, this is my issue.
Okay, we come to you very soon. But before we come to you, there's a quick reaction to, is it Joshua?
Yes, sir.
Yeah, a quick reaction to Joshua's issue. You know, if you look at the story or the fact as we are just looking at, we are not told when the Guard Petroleum Company Limited actually obtained their grants from the LASU. I think we don't have information in terms of the timeline from the story, isn't it? So
yes, sir.
We are not in a position to definitely conclude as whether it preceded the 60 years, what do you call it, the possession, or after. So we have to be careful. But now let me take the other gentleman. Somebody wanted to.
Okay, so Doc, my issue will be whether or not the grants made by the last two to petroleum companies valid.
Okay, so whether the grant by last two to GPC Ltd is valid. Okay. Okay, so let's move on. They produce a document executed by the Mantse and his elders for the company. Any issue?
Yes. So whether or not the documents they produce supersedes any other right on the land or any other interest.
You know my difficulty with that. We haven't seen the content of the document, okay? And for that matter, we will not have information to discuss, assuming we frame an issue around it as you are suggesting. So we may not have to build an issue around that, but it will be useful when, for example, we are discussing the issue which we just raised, as whether the grant by LASU to GPC Ltd is valid. Like when we are discussing that, in that bit of information may be necessary in the analysis and application. Okay.
Very well.
Yeah. Okay, George, you want to say
the
something?
Issue.
Yeah, I think whether or not the grant by LASU to GPC Ltd is valid should come after they produce a document executed by Mantse and his elder.
Oh, right. Okay. So it's
like
it's all the same narrative. Okay.
Yeah, so that we can properly address the two.
Okay.
Yes. But I believe that it should be the Mantse and principal elders.
Yeah.
But here we have only one.
Okay, Joshua, before you continue, then I heard a female voice. So if we can let her make a point. Yes, please, go ahead.
Oh, sir, that was the issue I was coming to raise, whether or not only the Mantse and his elder can alienate a plot of land.
Oh, right. Okay.
Yes.
All right.
Yeah.
Okay, now let's go to the latter part. Amerley and her mother have consulted you. Of course, we don't need what are their chances if they go to court, support your opinion, decide the case and reference. Okay. So now let's see how did you get?
4.
Well, how many issues?
You have 4, sir.
So issue 1. Oh no, that would be issue 2. Yeah, you see the advice that we keep giving you, if you heed it, especially like how we formulate the issue. You notice that if you take your time and you engage every sentence, at least you will not go wrong in terms of missing out issues. The only, probably, the worst case scenario would be that you raise a lot of issues, but that one in itself is not is not a negative. If you raise a lot of issues, there's nothing wrong so long as you're able to address them properly. It's better than you just having a global approach at the story, just complete issues without going by sentence, and then you end up, missing out maybe some important issues. Yes. Good. So we have issue 1, whether Ajorkor, by virtue of being a subject, is entitled to usufructuary interest. Of course, how it is framed can be framed variously. So in terms like the framing is not really important, but the substance of the issue, which is important. I think before, of course, if we are doing our own answer, you notice that we take the issue and then we have to state the relevant law. And in stating the relevant law, don't forget that here, the law now is both statutory and also case law, as well as probably some test writers like Oleinu and Saba and things like that. But in the examination setting, despite the fact that the question said that and make reference to test writers, we don't expect details of that, apart from maybe some generalized reference to some of these leading authors, assuming you don't have like a statutory provision or don't have like a case law which actually support a particular point that you are going to make. So those are the general things we have to keep in mind. And when you have finished like the law, then under that particular issue, as we indicated, you will try to do the analysis and the application. That is trying to show whether the facts that you have, they answer the requirements of the law that you have stated, and then you conclude on that particular issue, and then you move on that fashion. Good. So in the spirit of that, let me invite one of you to state the law for us as far as issue 1 is concerned. But sometimes some issues are related, okay? So for example, if you take issue 1 and issue 2, you see that they are related. So related issue can be treated together. Okay, so there's nothing wrong to have maybe like issue 1, and then you stated issue 2, then you underline, then you state the law, because it's basically like the same principles or the same law, which are relevant to those related issues. Then when you are doing the analysis or the application, then you try and do it separately, so that if with respect to issue 1, the stuff that we say will be different, and also with respect to issue 2, it will also be different, despite the fact that it's basically like the same law that you are using. So let us keep that in mind. Okay, so what are the requirements for recognition or acquisition of usufructuary interest? What are the incidents? And you see, the thing you should also remember is that, assuming you got this question of 2016, now we are in 2022, and we have the Land Act 1036. So the marking scheme, which was provided in 2016, would be slightly different from what we have now. The reason being that now we have like a whole Land Act, isn't it? Which has more or less enacted some of these customary law principles on land. So that is the other point to note. So now, if you talk about usufructuary interest, for example, we will not do justice without paying attention to Section 5, isn't it?
Yes, sir.
To Section 5 of the Land Act 2020-36. In Section 5, among other things, will tell us, I'm just using the text of the law, that is usufructuary, it's an interest in land which is acquired in the exercise of an inherent right by a subject or member of a stool or skin, or family or clan, which holds the allodial title through the development of an unappropriated portion of the land of the stool, family, or clan, or by virtue of an express grant. Okay, so the first part, what you have to get from the statement of the law as per Section 5, subsection 1, paragraph A, is that in trying to identify whether someone actually has the usufructuary interest, you must find out first, is the person a member of the stool or the skin or the family, which has like the allodial. That is the first thing. And then 2, we have to find out the particular parcel of land which he or she is trying to lay claim to in terms of having the usufructuary interest. Is that land unappropriated? Unappropriated means that it not be reduced into cultivation or into development by another person. In other words, is it like undeveloped land? It is unappropriated land. Because if another stool subject or skin subject or family member which holds a allodial, for example, has already reduced it into some form of development, you cannot seek to assert usufructuary interest in respect of that land. So one of the key things we should keep in mind is that the particular parcel of land you are seeking to claim the usufruct in must be unappropriated. Unappropriated simply means that it must not have been cultivated or must not have been developed by any other person or entity. So let us keep that in mind. And that is why, if you read the old text writers like Benchienchel and even Olenu principle of customary law, the point to be made that if you are a member of the stool or the skin, which has a allodial, wherever you are machete, like your cutlass, weed up to, that is where you have actually acquired the usufructuary word interest. And that means that if where your cutlass will enable you to weed up to, that means that that place is uncultivated. Is because if it's cultivated, then you are sort of like making trespass and so on, as it were, isn't it? So let us keep that in mind. And then B, I'm still quoting Section 5 of the Land Act. And as I've told you now, some of these principles, which we have cited a lot of old customary land law cases, Ohimen and J, Abude or Nano, and so on and so forth. Most of these principles, which were scattered there, have now been reduced into the statutory provision. Yeah, and that is why I'm saying that if you have like the marking scheme now for this same question, which was set in 2016, it will be slightly adjusted to reflect the new development per Act 1036. Then B, usufruct is an interest in which is B. That is the alternative way of acquiring it. Acquire it through settlement for a period of not less than 50 years, with the permission of the holder of an allodial title by a non-indigent or group of non-indigens or descendants of a non-indigent or group of non-indigent, except where the settlement is on agreed terms. Yeah, so the alternative means that is where you are non-indigent. Non-indigent here, we're not talking about a non-Ghanaian. So don't let us make a mistake. Non-indigent here, we are talking about you not belonging to the family or the stool, yes, which actually holds the allodial title. So that is the indigent here we are talking about. And that is why if you go to the interpretation section, right? If you go to section 281 of Act 1036, which is the interpretation section, if you go to page 147, indigent is defined there as follows, and I quote, indigent means a person who, in accordance with customary law, A, hails from a community or settlement, and B, is a subject of a stool or skin or member of a clan or family, which holds allodial title to land, unquote. So therefore, by the non-indigent, which is referred to in section 5, subsection 1B, that if you are non-indigent, you can acquire the usufructuary interest if you have settled on the land for a period not less than 50 years. And if you came onto the land with the permission of the holder of the allodial title, then you will be able to acquire the usufructuary interest. And C, inheritable and alienable. So you can also acquire it. There's the same normal that principle. That is, if you have a usufructuary interest, you can also pass it on, and the other person, so long as you have followed the proper process of alienation, will be able to acquire the interest that you also had as it were. But then we have to look at the subsection 2. That is a section 5, subsection 2, and then we are done, and then we come back and discuss together. Where alienation of the usufruct is to a person who A, is not a member of the stool or skin or clan or family which holds the allodial title, or B, is not a non-indigent or from the group of non-indigent who holds the usufructuary interest as provided in paragraph B in the land in respect of which the usufruct is to be alienated. The alienation is subject to the written consent of the stool or skin. So you have to pay attention to this, the written consent. Mind you, written consent was not really part of the customary law, customary land law, as we used to. It developed through the case law. And now some of these principles from the case law have been enacted into a statutory provision, right? So like in a typical customary law transaction, we are now insisting that if you are going to have alienation of a land in respect of which there's a usufructuary interest, and you are going to do so to a non-indigent, someone who does not belong to the company, to the stool or the skin, like someone who's a stranger, so to speak, and all that, then you need a written consent of the stool or the skin or the family, which actually holds the allodial title. And of course, there's also a requirement of performance of established customary obligation. Because don't forget that a stool or skin subject or family member is entitled to enjoy the usufructuary interest in the sense of reducing the land in respect of which the allodier is held to his own enjoyment, because if there is war, being a subject, he will go and help the stool or the skin or the family to defend the interest and all that. And that is why it is very simple that so long as it is not cultivated, so long as it is unappropriated, you can reduce it. Therefore, if you are not a subject, you don't have some of these customary obligations that if there is war or if there is any festival and so on, you're supposed to help the allodier holder to perform rituals and so on. You don't bear those burdens. And that is why the law per section 5(2) is saying that if you are non-indigent, then you are supposed to, there's supposed to be like a written consent, that is permission from the allodier title holder, that yes, you, the usufructuary interest holder, you can alienate or you can pass on quantum of the interest that you have to this non-indigent, so long as it's prepared to perform the requisite customary obligations as it were. Good. So in a nutshell, this is the law regarding how the allodier, the usufructuary interest, for example, comes about now. And as I said, this has been simplified for us because of the Land Act. And previously, these things that you have said, we have cited over 10 different case law. 10 different case law, but these have all been simplified in the provision now. So that is the advantage that we have now with this legislation. And thankfully, since this legislation came, we've never had a significant interpretive issue, maybe in the court, where the court will, for example, say that this provision means this or it doesn't mean that, and so on and so forth. So therefore, let us go to Act 1036. So long as that is the law. And since that is the law, if you know this and use this to solve it, nobody can mark you wrong. That is the law. And that is why I said that 2016, the approach will have been different because we didn't have this. 2016, all that we had was the land title registration law, PND's law 152. Then when it is listing interest in land in Ghana, then to mention the usufructuary interest, but beyond mentioning it, it will not tell us in a statutory format what the incidents of usufructuary interest are, as well as the mode of alienation. You needed to get answers to those by working your way through married of a case law, right? Yeah, but now, as you can notice, there have been some synthesis of some of the principles from the case law, and then they are now all collected in one place for us. Good. So, somebody said we should adjust the screen. Can you see the screen? Yeah, I think you can see it now. Sorry. Good. Okay, so now I invite one of you to take us to resolve issue 1.
With the issue 1, as to whether or not Ajorkor, by virtue of being a subject entitled to usufructuary interest, as per section 5 of the Act 1036, try to explain what usufructuary interest is. He says that the person is a subject to the stool and the person occupy uncultivated area of land. Okay, then it talks about how it is being alienated. So the fact that the person is a subject and occupies that land, uncultivated land, that person occupies the usufructuary interest to that. And it continued to say that it is inheritable and it is alienable. So as was stated in the case of Kwame Nkrumah, he says that where your cutlass will take you, that will be the portion. So it means that when you look at the fact of the case, applying it to the fact of the case, we can see that Ajorkor is the subject of the Alodia title holder. Is a subject of the Stool Land. That's to end. For that matter, being in possession of the land for that 60 years permit Ajorkor to obtain usufructuary interest in that land. So that is issue one, how I see it.
Okay, just a few comments on what you have done. Yes, you've made a good effort, but Joshua, you cited yes, Kwame Nkrumah wherever your cutlass
would take.
Yeah, that is fine. But then I would like you to start with the statutory position first. We have to appreciate what we call the hierarchy of legal norms. So when you are dealing with rules, consistent with Article 11, if you have a relevant constitutional provision, that is first. If you don't have a relevant constitutional provision, and then we have like a statutory provision, then that is first, before you have like a case law, okay? So as I indicated, now we have the Land Act. So if there is any dispute as whether there's virtual interest or not, the litmus test will be the framework we have in section 5. Yeah. So then the application B2, the other thing I saw, Joshua, which you need to pay attention to is that, of course, once we have the last two, you can just say that the fact that the land in issue is for the last two. So presumably, last two is the holder of the Alodia title. And again, in terms of like that, we also give you information that Ajorkor is like a subject. Okay, now let's find out from the law. The law says that you can have this virtual interest in an unappropriated land. So that aspect did not come up in your application or your analysis, Joshua. So, Joshua, I don't know if you get my point.
I get it.
Yeah. So, in your response, you need to also let that come out. That because if you look at the story, we are told that Ajorkor has farmed for how many years? For 60 years.
60 years.
So you use that, you see, and the 60 years here is not, don't let us be misled by section 5(1)(b), because section 5(1)(b) is talking about where you are a non-indigent, then you've occupied the land for not less than 50 years. Because here, clearly, being a subject, she's indigent, meaning that she's member of the stool or the skill holding the Alodia, isn't it? So
yes, sir.
The point about not being indigent does not come in. And for that matter, the section 5(1)(b) that you shall have been on the land for not less than 50 years is not important. Despite the fact that in the story, we are told that Ajua has farmed for 60 years. So that is a bit like a red herring. Yeah, but what we can use that piece of information to do is to, for example, logically infer that if she's found on the land for, of course, there's even information that the vacant there's a vacant last two land. So that is, vacant means that it is unappropriated, isn't it? Because we are told that she found on the vacant last two lands. So once it's vacant, it means that no subject or nobody has done anything on it. And for that matter, what the law says is satisfied. And legitimately, the Ajorkor could have the usufructuary interest there, as it were. Unless you have questions, otherwise move on to issue 2.
A freehold type carved out of the allotment.
I think the issue 2, as I said, if more or less address it, isn't it? And we make the point that since Ajorkor is an indigent, in other words, is a subject, or which holds the allodia, the length of possession prescribed by law, that it should not be in less than 50 years. It's not important. It's not important. So we don't have to waste time here. If Ajorkor were to be like a stranger, like not belonging to the last 2, which holds the allodia title, then we could have made good use of the 60 years possession, which will have satisfied the legal requirement that if you are non-indigent, among other things, you should have been on the land for not less than 50 years. But in this particular case, the Ajorkor we are dealing with is an indigent, so that this is not really important. So let's move on to the next issue. Who will take the next issue for us? Somebody should state the law for us. Whether or not Ajorkor can unilaterally alienate portion of the land to Amerley. Who will state the law for us first? Yes, Jack, go ahead. Yeah, Jack hand is up. Go ahead.
Yes, sir. Sorry, sir, I want to go back to
what we're doing. Okay, no problem. Sure.
No, when you go to 182, section 182 is saying that
182. Okay.
Yes. Registration of stool.
Registration, yeah, of stool. Okay, go ahead. 182 subsection.
Subsection 1.
Okay.
So he's saying that it's a vacant land, and whether or not the last tool they satisfy the registration of the land.
Okay.
I don't know whether you.
No, I'm listening. I'm listening. Go ahead.
No,
like so. If so, your concern.
Yes.
Your concern is the point I made that look at section 5. If you look at section 1A, among the requirements for acquisition of usufructuary interests, the particular portion of land must be unappropriated, meaning that it must be vacant or it must be undeveloped or uncultivated, isn't it?
Yes.
Yes. And what is the problem?
No, because I was seeing the vacant land.
Yes.
Whether or not the last two they have satisfied the 182.
182 says that subject to this act and any other enactment, where land or interest in land is vested in a stool or skin, a clan or family, the stool or skin shall be registered as proprietor of that land or interest. Now, so here, you see, let me explain this. What has happened is that where you have a particular parcel, a particular area, please, if you are not talking, mute yourself so that we have a good. So let's say that where a place has been declared like the registration district, right? Just as we used to have under the PND 152, which has never been replaced by Act 1036. You want to register all interests held in a particular parcel of land. within an area which have been declared a registration district in accordance with the land title registration scheme. So within the context of that, where you have, if you like, a land which is even like a vacant and so on. Now, in terms of who the proprietor is, the particular family or the stool or the skin which holds the allodia will be registered as a proprietor. So that is the intent of the section 1A2 that you've referred us to. So it is good, but it's playing a different role, which does not affect the substance of what we are discussing now. Especially so, the question is silent. If, for example, the question said that the place has been declared a registration district and all the lands there have been, all the interests in land have been registered under the land title registration scheme, that's the law, then it will be legitimate for you to be making some of these extrapolations and inferences. But without that piece of information, we don't need to worry ourselves and go in that direction. I don't know if that clarifies.
Yes, sir. Thank you very much.
Okay. All right. So let's move on with the next issue. Whether or not Ajorkor can unilaterally alienate portion of the land to Amerley. Again, as I said, this issue can be framed in various ways, but the substance is here, so we can work with the substance. So who will state the law for us? State the law relating to alienation of alienation by a holder of a usufructuary interest.
Okay, so from the law is that if a holder of usufructuary or usufruct would want to alienate or transfer that interest to an indigene, that the holder does not need the written consent of the allodia. However, if that alienation is being given to a non-indigene, written consent of the allodia owner is required, as espoused in section 5.2 of Act 1036. And so to apply it to this, what it means is that Ajorkor is a subject of the Stool Land. The daughter Amerley is equally a subject of the Stool Land by virtue of the bloodline of her mother. And so on that grounds, Ajorkor does not need the written consent of the Stool Land. And so the grant by Ajorkor to Amerley is valid.
Okay. Do you have any? Yes, before I take the lady, just the gentleman who just finished. Do you have any case law to where the facts and the decision are similar to what you have on hand? Yes.
I don't know whether a war and a dispute will be applicable.
What happened there?
So in a war and a dispute, the land had been cultivated by the plaintiff for some time, and then so the land had been cultivated by the plaintiff for some time, and so it turns out that the occupation was being challenged because he had transferred the interest that he had to the descendant, and so it was held that the holder of a usufruct can transfer or can alienate the interest that he had because it is transferable. And so, but because the Land Act had not come, was not done in that case, and so I can infer from the holding of that case and apply it here.
All right. Okay. All right. Okay, that is fine. So long as you be able to cite the Land Act, and if you also have like a case law, if you cite it and it's relevant, I think you just attract more smiles from your examiner. Yes, yeah. I think a female wanted to make a point. Yes, please go ahead.
Yes, Doc. Please, I wanted to draw our attention to the section 5.1c, preceding what the gentleman said. I think it has to be established that usufructuary interest is inheritable and alienable before we go to the part with the written consent.
All right. Okay.
Yes, please.
Yeah, so it's
Thank you very
inheritable and it's alienable. That is true. And on this particular occasion is the alienation or alienability, which is implicated since the inheritance bit from the facts. We don't have like the inheritance bit, so that is fine. Okay, good. Then the other thing I should draw your attention, please, let's look at section 8. Section 8 of the Land Act, Act 1036. If you look at section 8, it says, and I quote, subject to subsection 2, 3, 4, 5, 6, and 7, the bundle of rights and obligations attached to any form of interest in land shall be determined by the applicable source of law, which is the basis of that interest, unquote. So what that means is that despite the fact that Act 1036 has enacted most of the principles laid down in the case law, it has not shut the door completely to the relevance of the case law, especially where the statute is silent. So where we lack clarity concerning whether a particular right is part of the bundle of rights which a holder of the usufructuary interest should enjoy, or maybe certain obligation, we can still go back to case law so long as we do not have the answer in the Act 1036. So let's keep that in mind. But as you have rightly discussed, in this particular case, we're not dealing with a non-indigent. And because we're not dealing with a non-indigent, it will not be very complicated because the requirement of getting the written consent of the steward and all that will actually not be important. But what about the point that what did she give the land to Amerley to do? It's not for farming, remember? Do you remember it's not for farming? What did she give her to do?
To build.
To build, good. So if you are a holder of usufructuary interest, can you just alienate to anybody to go and build? If it's for farming, it's straightforward. But for building, is that simple? Or you have to bring the stool involved?
Hello, Doc.
Yes.
Yes, please, Doc, I wanted to indicate that in relation to the earlier speaker's submission, that
it's not for farming.
No Tata versus Mam case.
No, yeah.
The court decided that a subject in possession may alienate that possessory title of his or hers, either to another subject or to a stranger, or he may lease it so long as such alienation or lease carries with it the obligation to recognize the allodial ownership of the stool.
Of course.
When the court actually had to determine whether or not a subject in possession of stool land can alienate or lease his possessory title. So in relation to this particular principle, so long as whoever is leasing the land to will acknowledge the allodial owner of his title, then he can go ahead and make this alienation. However, because the daughter was going to use for housing purposes,
yeah,
it's still valid for her to make this house. But it goes also to indicate that so long as they are on the land, and they can prove successorship and they are not even extinguished, they will forever be in possession and because an inherent right. And they are not restricted to only farming activity alone.
That's it. According to Lord Denning,
All right.
they are not restricted to only farming.
Okay. All right. All right. Thank you. So let's go to, I think, the last.
Yeah, you are right. You're doing it well. You are shifting it. That's good.
Okay, so let's go to the last.
Doc, please, I want to ask a question.
The lady. Yes, please go ahead.
Yes. Please, looking at this lineage system and you post with the submission made, a lot of people are saying that she is will be considered as an indigene. But looking at the gas system, being patrilineal lineage, I don't know. I'm still thinking about that. Would that also change something?
Oh, right. So you want to argue that because the GA is a patrilineal, but of course
yes.
the GAT will have to be careful. If you look at the writings of Ole Nu, it's not all GAT places which is patrilineal. There are some places in Accra, under the Osu and some other places where they have a bit of matrilineal, isn't it? Yeah, so we need to pay attention to that. But having said that, so long as what is really an issue is not about inheritance, right? If it was maybe assuming there was an issue of maybe like the inheritance and things like that, then we could pay more attention to that. But I get your point as to whether, let's assume that the particular the last two, let's say is the patrilineal system, and the lady, she's not a member of the family. So, being not a member of the family, is she an indigene within the meaning of the law? That is your question.
Hello, Doc.
Yes, please.
Yes.
Doc, that's why I indicated that from the no created a case.
Yes.
The court actually did indicate whether he's alienating to an indigene or a stranger. So long as he is alienating to somebody who will recognize the title of the allodia ownership,
yes,
then it was the person could make such a grant.
Right.
So it didn't matter whether the person is an indigene or a stranger.
Right. Okay. All right. Okay. Lady, are you satisfied, or you still have a counter?
Yes, I think yes. What is establishing is there, but looking at the section 5 with the non-indigene thing, that is why I'm a bit.
No, but see, please, let's go to the definition of the indigene again in the section 281. Specifically at page 147. It said that indigene means a person who, in accordance with customary law, hails from a community or settlement. So he is talking about community or settlement.
Yes.
So we are not talking about the family.
Okay.
Because that hails from a community or settlement. And B is a subject of a stool or skin, a member of a clan or family which holds a allodial title to land. Yeah, so, but if you look at the statutory definition, because of the use of the conjunction, like they have the conjunctive word "and," the argument to be made. Of course, all these things are yet to be properly tested in the litigation. Some of this Act 1036 is relatively new, and it's going to be tested in the real litigation. So some of these things, the rough edges have not been worked out properly. Because if you look at the way that the indigene has been defined, right, in the law, it's like we have like a double barrel test. First, you must hail from the community or the settlement, and secondly, you must be a subject or member of the family or the stool who shows the allodial. So if you are going by that, then what the lady is posing as a question is something which is legitimate. But that's I indicated. That's I indicated. All these things have not been really tested in litigation, so there's still a lot of we have rare case law pronounced upon them. Okay, so thank you. So I think we should be making progress. Okay, the last one. Whether a grant last to GPC. Please, can you mute yourself? We are getting feedback. Okay, let me mute William. Okay. Yeah, so whether the grant by last two to GPC Limited is valid. Who will state the law for us?
Okay, Doc. So let me try.
Okay.
So because of the order of laws, I will start from section 68(9) of the Lands Act, which establishes that grants of land should be done with the occupants of the stool and in concurrence with all members of the all elders of the stool.
Which provision they do cite, please?
68(9).
68 now, all right. Okay. Yeah, go ahead.
All right. So subject the occupant of the stool, subject to all elders of the stool.
Yes. No, 689.
689. Am I correct, please?
Yes. Yes,
all right,
go ahead.
Thank you. All right. So the occupant of the stool, including all occupant or all principal elders of the stool, subject to a particular customary law. And then when you look at the case of Akunsa versus Buchi, Akunsa versus Buchi, the court held that if the grant is by the occupant of the stool with the minimum number of the elders, the grant becomes voidable. However, if it is granted by only the occupant of the stool, the grant becomes void. If the grant is by the occupant of the stool or by elders of the stool or an elder of the stool without the consent and concurrence of the occupant of the stool, it also becomes void. And this same principles was also espoused in the case of Apia Nchi and Nana Nyama. And then with Ukutete, Uku and Tete, the court held that for there to be a valid grant from the stool to any other person, it has to be done with the occupant of the stool with concurrence and consent with the majority elders of the stool. And so in applying the case or in applying the law to the fact, the grant to Guard Petroleum Company was done by the Mantse and his elder. So what it means is that the grant was done by the occupant of the stool and a minimum principal elder of the stool. So to that extent, what it means is that the grant was not validly done, and that grant is voidable. What it means is that steps can be taken to either set it aside or perfect it.
No, but let me ask you this question. You've not addressed the fact that that same land, the a subject of the the stool having the allodia had a usufructuary interest, and you have also, we've already argued it out that there had been a valid alienation of that to Amerley. So what do you make of all that?
Okay, so what I make
alleged grant to GPC Ltd.
Okay, so what I make to that effect is that the stool does not even have the right to even grant in the first place, nemo that non-court habit principle, because it has been occupied by a usufruct who has that inherent inalienable right, and that person is in occupation already, and so that grant is also void ab initio. Thank you for drawing my attention.
Yeah. So you have, for example, just in stating the law, you have stated it the way that you did, but then you also make the point that you can only, the stool can only go through those valid process of alienation where it had the particular land to so alienate. But in this particular case, if the resolution of the issue regarding the alienation to Amerley, for example, is to stand as valid or as accurate, then the land which GPC Limited claimed was granted by the stool will not be there. Somebody is saying that we should refer to section 50, subsection 22. Isaac, okay, let's look at it. Section 50, subsection 22. Okay, so 50 subsection 22 says this, and I quote: the holder of an allodia title shall not take over land under subsection 21 without a prompt payment of fair and adequate compensation, which in any case shall not be less than 40% of the plots of land or the market value of the plots of being taken over, or B, providing suitable alternative land where possible to the holder of the usufructuary interests in respect of the land. Okay. Now, it made cross-reference to 21. So let's go to the 21 and look at what the 21 says. A holder of an allodia title may A, in furtherance of the expansion of a town or settlement, and B, for purpose of serving the communal interests of the beneficiary of the allodia interest, take over bare land or farmland which is subject of usufructuary interest within the area covered by the allodia title. Okay, so the person who referred us to this provision, Isaac Inkum, thank you very much. But then let us notice that that provision, the 50 subsection 21 and 22, is speaking to where you have a bare land or farmland, which is the subject of usufructuary interest. But in this particular case, the land which Ajorkor alienated to Amerley is not bare. At least from the story, we are told that she commenced building. But when she commenced the building, she was confronted. So the question is, her commencement of the building and then the purported grant by the holder of the allodia, that is the last two, to GPC Limited, which one was first in time? And assuming the purported grant by the last two to GPC Limited was first in time, we have to test it against the provisions in section 22, which Isaac has drawn our attention to. That is section 50, subsection 22, that the allodia title holder could, for example, make a grant, provided that necessary compensation or alternative a suitable alternative land is made available to the holder of the usufructuary interest. So from the facts, we do not have information that any such alternative arrangements were made by the last two, or any fair and prompt compensation was actually paid by the last two to Amerley and Ajorkor, who have the usufructuary interest, as it were. And for that matter, we cannot say that there has been like a valid grant by the last two to the GPC Ltd. Yeah. Yeah, Isaac. Yes.
Yes, please. I also want to add that from the case of Igmati versus Aditya, the court did hold that an indigent cannot obtain a usufructuary right in land that has been reduced into occupation by another usufructuary interest holder or a stranger with a valid title, which has got to mean that if somebody is already in possession, a stranger, even also having title, cannot obtain any valid interest or title. And as you did mention, priorities, even if priorities are easy to go by, the equity will indicate that when the equities are equal, the law prevails. But there are exceptions to the law prevailing in that there are notices. So if the stranger, after the time you went on the line, somebody already in occupation, you will be fixed by notice. Actually, because the person was already farming, has even started even putting up building. So he'll be fixed with actual notice, and he cannot, it will lie in.
No, yeah, I appreciate the point you're making, but don't let us forget that section 50, subsection 21 and 22 is trying to reenact some of the modern case law from customary land law alienation, and also adding to the customary law by saying that if the town is expanding, for example, and then the stool or the family having the allodia will need to get the particular land for communal purpose or general use of the community or something like that, it can always take over a land in respect of which its usufructuary interest is held, so long as it is bare. That is, it's just there, or it's bare, or it's a land, it's a farmland. The only caveat is that compensation arrangements should be made, or alternative land should be given to the usufructuary interest, so that the particular land that he or she is having, which is needed for the communal use, could actually be taken over. So in a sense, you are having compulsory acquisition within the traditional community state, not the modern, like the Republic, as we have on the eminent domain. It's some sort of a compulsory acquisition by the stool or the skin or the family having the allodia. But these safeguards are there, that before you can do that, you must make arrangements for compensation, alternative land to be made available and all that. So let us keep that in mind. Okay, so yes.
But you did indicate also that the land we are dealing with here is not a bare land. The person is already in occupation. So the caveat also is that the allodia title can pick up the usufructuary interest holders' land and pay compensation. But that particular land must be bare. But in this particular question, the question is that it's already in occupation. So
the occupation, as in reference to Ajorkor doing the farming or Amerley about to commence the building, which one?
In both situations, because
no, but let's say for if it's the farm, because if you look at the section 50 subsection 21, okay, subsection 21, for example, if we read that, we are told that you can take over bare land or farmland, which is the subject of usufructuary interest, So farmland. So in the case of the Ajorkor one, is a farmland. So that will not prevent the stool so long as the other things are done from taking over. But then in the case of the Amerley, if Amerley had actually commenced before the GPC Limited got the grant, then you argue that, as you rightly noted, it was not bare because Amerley had done some work on it. But from what we are reading from the fact, is like when Amerley started, then she was confronted with the representative from the GPC Limited that they have interest in that land already, that the grant had already been made before Amerley even commenced work. But as I said, these facts were set in 2016, and they were set not with the current law in the shape of Act 1036 in mind. So all that we are doing is that we are doing some kind of a creative analysis and thinking that, assuming we have the same set of facts under the current state of the law, how will we go about it? That is what we'll be doing so far. And so far, so good. So you will certainly, tomorrow, I think I'll try and have about 2 or 3 different sessions with you. So when I'm ready, I just put it on the platform. If you have the time, then you come online and join. Maybe you meet about 3 times throughout the day, depending upon my availability. So have a very good night, and then we'll meet tomorrow, God willing.
Thank you, Doc.